Executory contracts and unexpired leases play an important role in many asset acquisitions in bankruptcy. As you probably know, Section 363 of the Bankruptcy Code governs the sale of a debtor's assets. Section 365, on the other hand, governs the assumption and assignment to a buyer of the debtor's executory contracts and unexpired leases. An unexpired lease is pretty much what it sounds like, a lease that still has time remaining on its term. But what's an executory contract? Well, oddly enough, the Bankruptcy Code doesn't actually define it. In general terms, an executory contract is one that still has performance due on both sides. So I agree to sell the debtor widgets for its manufacturing project, the debtor agrees to buy them and pay me for my product. I agree to distribute the debtor's products, the debtor agrees to pay me for my services. I agree to let the debtor use my trademark in its business, and the debtor agrees to pay me royalties. These are all basic examples of executory contracts. If you're acquiring substantially all of a debtor's assets and plan to continue the business as a going concern, it may be very useful to you to be able to step into the debtor's contracts and leases. Section 365 of the Bankruptcy Code lets you do that, subject to some limitations. So, how does it work? Well, one question I get a lot is, how does the debtor decide which contracts and leases to assume and assign? Well, that's a very easy one. You, as the buyer, get to pick and choose which contracts and leases you want. The sale order that eventually gets entered by the bankruptcy court will include approval of the debtor's assumption and assignment to you of the contracts and leases that you've identified. Whatever contracts and leases you don't want will not be part of the sale order, and you'll have no liabilities or responsibilities for them. What if the debtor's in default under a contract or lease? Well, in order for that contract or lease to be assumed and assigned to a buyer, any monetary default has to be cured. Now, cured means paid in full, in actual whole dollars, not bankruptcy dollars. And in order to pin down exactly what those cure costs are, the debtor will file a notice of potential assumption and assignment of contracts and leases, along with what it thinks are the amounts owed. If a counterparty thinks that the listed cure amount is wrong, it has the obligation to file a timely response. Otherwise, the cure amount will be deemed to be whatever the debtor says it is. And this gives you, as the purchaser, time to review what it will cost to cure a contract or lease and decide whether it's really worthwhile. And this is important because, as a practical matter, the purchaser is generally the one who pays the contract cures, because in most cases, the debtor doesn't have the financial ability to do so. Now, of course, there can be variations that are negotiated. For example, you might negotiate an APA where the purchase price gets reduced on a dollar-for-dollar basis based on the amount of the contract cures. Or, more commonly, you might negotiate something where you agree to take responsibility for contract cures up to a specified cap, above which the cures then become a deduct to the purchase price. All right, well, what about anti-assignment provisions? The beauty of Section 365 is that in most cases, it will trump anti-assignment provisions in a contract and render them unenforceable. Now, the big exception is where applicable law excuses the counterparty from accepting performance from or rendering performance to a new party. And this comes up most often in the case of intellectual property licenses. You generally cannot take assignment of an IP license without the consent of the licensor. Now, sometimes you'll get lucky and the consent will already be drafted into the license itself. For example, a lot of patent licenses will have a carve-out where they expressly allow assignment to the purchaser of substantially of all of the licensee's assets. But otherwise, you should be prepared to negotiate with licensors if you need their licenses as part of the acquisition. Question I get a lot is whether contracts and leases can be modified when they're assumed and assigned. Now, there's the textbook answer to that, and then there's the real-world answer. Now, in law school, we all learned that contracts and leases are assumed and assigned under Section 365 cum honore, with all of their burdens, warts and all, as is, where is. In reality, you're only limited by what you're able to negotiate with the contract counterparty. If the counterparty's choice is either agree to the modifications requested by the purchaser and get a substantial cure amount paid in full, or refuse the modifications and have the contract rejected, chances are you're going to be able to reach a deal. Finally, if you're planning to take assignment of contracts and leases as part of a bankruptcy acquisition, you should be prepared to give the counterparties what's called adequate assurance of future performance, which usually just means, if they ask, demonstrating to them that you have the financial wherewithal to perform under the contracts on a go-forward basis. So this has been a pretty broad overview of the assumption and assignment of contracts and leases in bankruptcy. There are a lot of potential nuances and permutations in how assumption and assignments are negotiated and implemented in practice. So as always, it's a good idea to consult with experienced bankruptcy counsel if contracts or leases will be part of your asset acquisition.